Sorry, we should had to sit a bit late because of some religious function. Okay, yes. Yes.
I mean,
That tea garden land.
we don't after 1970.
You want some time? When do you when can you do this matter? We can fix it on Monday next. Tuesday have got many matters fixed. Okay, we can try on Tuesday also. Have you informed the other side? Okay, Sri B. Goswami Learned AAG has submitted that some more time would be required to obtain the necessary instructions. Para on request list on Tuesday for hearing. It's under the hearing column. Yes. This item number, this is item number 25. Okay, Gopal Krishna. Yes, Tuesday. Yes. Yes. The 22 matter till 25 pleadings have not been exchanged. Both Sri B.D. Goswami, both Sri B.D. Goswami Learned Counsel for the petitioner and Sri S. Bothakur Learned Counsel for the respondent numbers 3 and 4. 7. You're for 3 and 4. 3 and 4. Pray for and are granted 2 weeks time, 3 weeks time to exchange further pleadings. List after the autumn vacation. Motion. Motion is. Hmm. Which department has filed? Okay, you want to need to file reply. Have you informed the forest department? Yes. Anyone forest department? Sri A. Hussain, Learned Counsel, prays for and is granted 2 weeks time. 2 weeks time to file rejoinder to the affidavit in opposition filed by the forest department. Today is 4th. 2 weeks will be what? We'll have it on 19th, list on 19th. 19th September. Yes. Tuesday have fixed many matters. Thursday it will not be possible. We'll try on Tuesday. Thursday this court will rise early. Next Thursday. Tuesday we'll try. Or maybe Wednesday we'll try. Wednesday. A prayer for adjournment has been made on behalf of the Excise Department. Para list on list for admission on Wednesday. Date will 10th. 10th. Fresh matter. Then you want listing of the IA? When? Okay, Monday. When did you file the IA? Numbered. Monday. Orders, repetition of which year? What is the urgency? When was the last order passed? What was the order? What was the order? You come prepared, madam.
So first we clearly directed to the bank operators and they had also taken time to fix certain instructions. It's not from the long. Immediate coming.
Last listed when? June. Okay, Wednesday next. Out of turn is otherwise we are not permitting unless it's very urgent. Yes. Motion. Hmm. It- Okay. Heard Sri J. Sharma, learned counsel for the petitioner. It's also heard Sri J. Roy, learned senior counsel for the respondent numbers 3 and 4, who has informed that the affidavit in opposition has been filed. No, has been affidavit in opposition has been filed, wherein the issue of maintainability has also been raised. Para Sri J. Sharma, learned counsel for the petitioner, prays for and is granted 2 weeks' time to file rejoinder affidavit.
Document passed of interim order, where the case under the Posh Act, the committee is 3 years. So the chairman, there is a bias against the chairman. So she's already retired by virtue of the act, 3 years completed. So there's a new committee. So I want that matter to be listed, on Wednesday,
What is the urgency?
The Posh Act, not tax pending,
You are for the petitioner. Therefore, you file an application for stay vacating, we'll consider. When was it last listed? 25. Sorry. Yes. 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 Okay. Sri and Das, huh? London State Council is present. Fresh matters. Fresh matters. It will come for motion. Yes, you can have tomorrow or Monday. Have you filed or not? Okay. Tomorrow we can have. Yes. Sakiri Basu.
In that particular load, some there cannot be POP. So that's technically correct. Now, in that people also type, earlier officer found that Mathura railway station. Then paid an inquiry.
Oh, this principle is followed later on also. It is not only Sakari Basu. We will go by the principles of law.
5 years.
65 old lady. In today's context, 65 is not old. Many people will feel very offended. Some are nodding behind you. You may be in difficulty outside the court. Mr. Sharma, can you take the status?
Your notice is already directed.
One like moving. After demarcation, the land gets given to us by the circular itself. On that day, the solution was that none was there except us. Just to some
Technical correction, lordship, with demarcation, lordship, we cannot give position.
Some actions have been taken. It is found to be a non-FIR case under section 126 of the BNSS. No, this is there. Why should we? He will record his submission, will have this on record. No. After Sakari Basu, unless you make it an exceptional case, Sakari Basu has been reiterated, many judgments. Some action has been taken. You pursue that. Heard Sri S. Dr. Learned Senior Counsel assisted by Sri D. J. Midhi. Full stop. The grievance of the petitioner is alleged inaction of the Gauripur police station with regard to an ejahar lodged by the petitioner. Please have your seat. On 21/8/2025, para. This court, wide order dated 29/8/2025, after referring to the case of the Honorable Supreme Court in the case of Sakiri Basu versus so-and-so reported in so-and-so, had observed that the scope of invoking the writ jurisdiction is very limited, full stop. However, the learned State Council was directed to obtain instructions, para. Sri Dr. The learned Senior Council has submitted that the facts of the case on which the judgment of the Honorable Supreme Court has been rendered is distinguishable, full stop. Full stop. This court is, however, more concerned with the principles laid down in the aforesaid case, and the relevant observations are extracted herein below, full stop. In view of this court has also been, Sri H. Sharma, the learned State Council, has also placed before this court written instructions issued, furnished by the concerned officer in charge, Gauripur PS, as per which the inquiry pursuant to the ejahar lodged on 21/8/2025 was done, which culminated in a non-FIR proceeding against the accused persons under section 126 of the BNSS, wide Gauripur PS NFIR case number 504/2025 under section full stop. And the same has been sent to the learned court of the district and sent to the learned district magistrate, Dhubri, full stop, para. In view of the aforesaid discourse and the principles of law laid down, this court is of the opinion that no further interference is warranted, and accordingly, the writ petition is dismissed. The written instructions placed before this court are made part of the records. Madam, you are also appealing. And Bodloy, Revenue Department. Sakari Basuto ami quote koribo lagibo, ha? 20? Mr. Sharma, what is this?
Eviction. The case is the kind of I mean the commission of the different bad. There is a Petrol, which is periodic finance partner has been issued. And the longer resident issue to all the residents and including that I agree. That is the amount of your noticeable IC and answer 350.
15. What is your name? Chauhan. So, dog number 709. Yes. Hmm. 709. So why are you
So I mean
this notice has not been served upon you. It's a general notice.
and that's why you can detect some kind of breaking these all these things. Maybe.
Eviction which is clearly mentioned about the dock number 709, this is the government.
That only clarity.
I heard. We can dispose this off.
Okay.
How heard Sri M. Sharma, learned counsel for the petitioner. Also heard Sri J. Chutia, learned standing counsel KAC, and Miss Ann Bordelot, learned standing counsel Revenue Department. Para, considering the subject matter involved and as agreed to by the learned counsel for the parties, this writ petition is taken up for disposal at the motion stage. Para. Bereft of details, the facts projected is that the petitioner is residing at a plot of land, over a plot of land with his family for more than 5 decades. The said plot, measuring 3 katha 10 lacha, is covered by DAG number 312/278 within bracket N at Bokolia Ghat in the district of Karbi Anglong. And in course of time, periodic Khiras Patta number 145 was also issued to the petitioner. Full stop. The grievance of the petitioner is against a notice dated 28, what is it, 25/8/2025, issued by the Assistant Revenue Officer, Fulani Revenue Circle, on the subject of eviction. Full stop. Para. Sri Sharma, the learned counsel, has submitted that though the DAG number has been stated to be 709, since the notice has been served upon his client, there is an apprehension that his client may also be a part of the eviction process. Para. Sri J. Chutia, learned standing counsel, KAC, has, however, submitted that the notice firstly was not issued to the petitioner and is a general notice. Full stop. Secondly, the description of the land which is under encroachment has been clearly stated to be under DAG number 709, whereas the plot of land of the petitioner is of a different DAG. Full stop. He accordingly submits that the apprehension is without any basis. Full stop. Para. Ms. Bordelot, the learned standing counsel Revenue Department, has endorsed the submission of the learned standing counsel KAAC. Para. On a perusal of the testimonials of the petitioner, including the periodic Khiras Patta number 145, it is seen that the plot of land of the petitioner is covered by DAG number 312/278 new, whereas the description of the land in the impugned notice is with regard to DAG number 709. Full stop. Though Sri Sharma has explained that though the name of the petitioner is not given in the notice, since the notice has been served upon him, the apprehension has arisen. Para. In the considered opinion of this court, the receipt of notice, the mere fact of receipt of service of notice upon the petitioner, wherein his name is not appearing, would not be a reason for his eviction, more so when the description of the land in the notice pertains to encroached land covered by DAG number 709, which is a separate plot of land. Full stop. Sri Chutia, the learned standing counsel, has also submitted that the eviction proceeding would be restricted to the area of land mentioned in the notice. Full stop. Para. In view of the above discussion and the facts and circumstances, this court is of the opinion that while there would be no restriction to go ahead with the eviction notice dated so and so, in accordance with law, comma, the same has to be confined only to the land mentioned in the said notice. Writ petition stands disposed of. Yes, item 2. CGST. Okay. What is it about? Now you have to place the facts. I think long time back we had just had a cursory. We heard this for some time, I think. Okay, what is it about? Service tax has been levied upon you. What is exempted?
In terms of mega exemption notification, it is 26,012. And also executed irrigation work contracts, also exempted as per the same notification.
Exemption notice is dated 20.
Notification number 25.
Okay. The service rendered for construction of road has been exempted by this notification. Okay. And your service is for construction of road, manpower. So you say that
Digging of completing part, with some saying flows and all. The entire work is to be completed in all respect by me. I have done that work. That is entire scope of the construction. But the assessment authority has considered the rate of items, which by description says labor charges. And he has presumed that I have supplied a manpower. And for manpower supply, it is not exempted and he has levied service.
You said that your job was not to supply manpower, but to get the works done through laborers, and therefore you are entitled for the exemption under the notice of 26/2012. That is your case. Okay. What is the nature of the work? For? You were the subcontractor. For the construction of National Highway. Yes. Thereafter. Hmm. Yes.
Right. Second paragraph. If it says anything, completion and short case, not be submitted to education, secondary education, and it says about influence, so I was suppressing the text. And of course, persecution received by the state notice will use of providing technical services, service category. Manpower equipment or supply reduced service, passenger, without getting it, at least, service tax registration. This is the main point raised by the SC operator.
Yes.
Number page 26. Where is considered pool of item raised for my box contract. It will say labor charges for bed preparation and connectivity for DLC work, including patient was ready and QE, etc., completing all aspects as per classification and instruction of the delay in charge. Labor engaged 22 members, including 2 members special. The calculation of rate is as per CUF.
Where are you?
Pool of item rate, the table.
Yes, yes.
Labor charges for occupations and complete for PLC group. So this is the composite contract. Particular each of work in the composite contract has been described as but your lordship will find it both for the unit of calculation is cubic meter. If it has been a labor charges, it cannot be calculated in cubic meter. Similarly, lordship will find the second code, third code, different description of work is there. Then lordship comes to page 27. From another works contracts, the signal of rate has been ready, unit of calculation is running meter.
Yes. 2/8.
Now what is done is from the interface returns. If I may read from interface returns on 26 million of income tax and the tax rate of state notice, it reveals that the gross amount received for providing extra service under record with compliance services as follows. So he has taken 2 figures. One is from income tax 26 years and from a tax. It is aware that 26 years in respect of income tax pertains to the tax deducted at source. The entire contract value that is provided could be on that the that has to be done 10% TDS and it is reflected under 1026 years of income tax. So that figure cannot be basis if at all service tax is to be levied upon me, because service tax will be at all applicable in only on the service component. But here on 26 years, the entire amount in respect of supply of contract, supply of services as well as supply of goods, the TDS is deducted under the income tax provision. And my bank statement will also reflect other figures or other receipts received by me, maybe out of works contract or maybe some other sources. So these two figures cannot be basis for negative sufficient.
No, RD is made the basis of
Yes.
the S.
And the entire figure is taken as hand of supply by case for daily transaction. That's the case one. Then I'll take a look in page 31. Against the so-called notice I given my reply. Page 31. Point number 2, competing argument.
3-1.
30. There is. It says you submitted a defense reply on 22/5/2017. In the defense reply, the notice submitted the following. All the informed orders submitted by the notice during the period when so-called notice are not orders related to construction of rates in the sector from kilometers when so to kilometers. The main contractor is myself, Fitness Infrastructure Limited, for whom the notice was the construction. Work executed by the notice is the execution of dry leaf country and pavement quality country, they using laborers. Then I referred to the definition of works contract. Technical service under execution of works contract service 55 of section 65(105) ZZZ A of Finance Act 1990 as a any person works contract means to any person by any other person in relation to execution of works contract, excluding works contract with respect of roads. So this is excluded by way of definition itself. Then I'll take a logic to page 32. After the paragraphs in italics, from the above definition, it can be seen that the works contract in respect of road have been declared not to be taxable service in respect of section 5(1)(5) is and secondary. Further, we detect from 1/7/2012, construction of roads can be exempted under the section number 3.
You have already said this.
Yes.
Yes, 26/22/2012 we have mentioned. Notice number 25 of 2012. 2012.
Now, that becomes findings made by the testing order. Starts from page 39. Discussion and finding. The relevant for lines. I have carefully gone through the case record, defense replied to the so-called notice submitted by the state justice and submission made in course of personal hearing and relevant action to finance tax. I find that the earliest in the includes so-called notice that the same notice during the financial year and so immediate payment of certain tax, including also under the service category manpower institution and supply services classified. I also find that it is further alleged in the so-called notice that the fact regarding emission services by the same notice and the service category manpower institution and supply services is detected only when an investigation based on information was initiated against the notice record and interest to that. So he has started with the assumption that I have supplied manpower supply. Then I think a logic to page 14. During execution of important trend,
Yes.
some part of the contract which were assigned to supervise with respect of supply of manpower. It is a not like a bad towards manpower supply, but some part was there. I'll detect from the contract of this. Yes, in fact, at page 42, singular phrase with respect of supply of manpower. That is finding confused in para 2.7, the 3 points. Rest of the above, go for the one, go for the, I find that the contracts awarded by the service recipient when these index must be limited where for some, I manpower and not for institutional box contracts, that is construction of roads, dam, gather, etc., which were specifically exempt by parallel year notification numbers also. Ability 6.12 as amended. Therefore, I will be considered opinion that the notification during the period of 11, 12, 14, 15 had provided textual service under the service category manpower equipment and supply services covered under Sector 6 P44 of the Finance Act. So this is the final findings and date of which taking the entire figure of Form 26 of the income tax as well as my tax statement by services for the upon. And take an option and the works contract. Contract of very digital one. Page 1. Work order dated is 15 October 2009. And you also can mark the number of work orders as well as 09101500. To be relevant for consideration of other work orders. The scope of work shall be bed preparation, completing, joint filling, initial and final cutting, etc. relating with VLC and P2C works from paving all restaurants with labor and small use and factors as per specification and instructions of the interior itself. Then clause B. Sales tax and works contract. Even the contractor is considered as works contract, so sales tax is variable upon that of opposite works contract. Sales tax on work contract turnover shall be determined as source from your RA bills payments if applicable as per present state. Okay. Then I'll take a look to page 2, point number 3, under general terms and conditions.
Yes.
You want to work with your group and tackles and the same will not be issued to by us. You are to receive your authorized and applicant when to use that site for mixing of issue reports and also to receive instruction from our teams. So this is my responsibility for proceed works contract. Then we'll also come to page 5, which is schedule of item base, which I have also divided in the assessment order. Page 5, unit of measurement is cubic meter and the description says as labor charges for.
Where are you reading? Page?
5. Schedule of item base.
Yes.
And refers to preparation and completing and continuously work including additional production, writing and something, etc., completing all respect as per specifications.
You have shown this in the table at page 26.
Yes. But yes, for this consider the word labor charges and use the entire thing as labor charge. And my submission is that if it had been a labor charge, it would not be calculated cubic meter. It's a compression works. Now I'll take the last to page 6.
Page 6, yes.
Here is the contract, which is part of the main contract also, where separately for some work, I had to supply manpower. This is a separate contract. The lordship is subject. Different type of labor supply works at parts of it.
Yes.
Scope of work, different type of labor supply or DLC P2C work and other allied work at Patsala site schedule of labor rates as per election fee attached to these papers. Election fee is on page dot 11. This is also there in the assessment order. It is per hour. But when the manpower supply is as per manpower per hour.
Yes.
Page 40.
Of this bunch.
Yes.
Yes. Yes.
Like from page 41 up to page 100 are all the purchase orders for supply of materials. This note sent confirm I have tender.
How are these connected?
For my works contract purchase, since the opposite works contract, I have to make my own supply. I have to employ my own employees, my own use and tackle, and I'm completely working.
So you want to show that this is a part of the work, composite work. So it was not a work for supply, per se for supply of laborers. So therefore, the entire basis of levy of this tax, service tax, is not, is without jurisdiction.
With 20 years, that is for period. Entire amount can be paid for to me, maybe for supply of metals, maybe for work execution, maybe for supply of laborers. Is reflected with the income tax and a 10% TDS deducted, which is reflected under section 26.
Form 26.
Yes. That figure cannot be considered for levy of service tax. And again, the figure of the bank statements cannot be considered because that may include my works contract and other receipts as well. So that is my discount. Then I'll again take a lordship finally to page 101. This was during 1450. I had executed irrigation work. 101. Issued by the office of PhD irrigation. Nothing matter says that Watopuri, Vibari, no irrigation scheme, construction of headboard, copper dam, diversion channel, plus one, curtain canal, etc. Under BIP, PTC 2012. So these are works contributions executed. And schedule of work is on page 102 with respect of irrigation.
Yes.
These work were executed during the financial year of 2014 and 15.
Yes.
Now I'll take a look at the notification. With your lordship, you will find at page 54 of the petition one.
Now, how is this connected 101? How are you trying to rope in this? Yes. 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 This is also one of the subject matter of challenge or what?
Yes. And which was the extent at 30 megawatt. So the figure which has been taken under 26 years and 10 is not, cannot be the basis for levy of service tax.
Here irrigation, where is the exemption of the repetition? Yes.
Page 55. Clause 12. D. Clause 12 reads. Services provided to the government or a local authority or governmental authority by way of construction, erection, commissioning, completion, fitting out, repair, maintenance, refurbishment, and operation of the canals, dams, or other irrigation works. Then, clause 30. Services provided by your construction, erection, commissioning, installation, completion, fitting, repair, maintenance, refurbishment, and operation of a road, bridge, tunnel, or terminal of road transportation for use by general public. And Lordship also point 29 on page 58. Nature of services are exempt and who are exempt, even the subcontractors are exempt. Lordship on page 58, clause 29, services by the following persons in respective capacities. Subclause H. Subcontractor providing services by your works contract to another contractor providing works contract service which are exempt. Even the subcontractors who are supplying, making services or in works contract, respect of categories which are strictly exempt under service tax, also be exempted. In view of the
Yes.
here what's it teacher. I think one thing teacher that up part was rent or supply. It was towards inclusion of works contract or construction of roads. As per the notification, I being a subcontractor, the main contractor, where the main contractor was exempted the works contract for construction of roads is exempt under service tax. Even the petitioner hearing, where he is a subcontractor, will also be exempt under the service tax. And no services can be levied for the.
But for the component where you had actually supplied laborers, that will not fall within the exemption. Well, how much is that component? Has the revenue made any exercise to divide, to ascertain what is the component? If because you admit that there would be some part which may not be per se termed to be a part of the construction work, but maybe termed to be supply of laborers, which does not fall under the exemption of this June notification.
Bills were raised to them. Now, those bills has to be segregated and has to be checked. The SC authority has not gone into that exercise and is simply relied upon the entire figure of Form 26 years and the bank statement or levy of services. Unless that exercise is gone into, possibly that application cannot be made. Calculation of a levy of service tax based on Form 26 years. Have done an exercise, but no cases come up before the High Court, any other High Court or the Supreme Court. However, the custom excise and service tax tribunals have been sitting with these matters that have been giving brief to the SSCs, saying that Form 26 years figures cannot be considered for levy of service tax.
Yes, anything else we'll hear, Mr. Khan? This is your. you base your entire arguments on the notification of 26/2012 and the specific clauses of this notification are clause 12D, right? That is for irrigation, 13A is for road, and 29H is for even giving benefit to the subcontractor. And you also try to contend that since the principal contractor to whom you had also supplied some labor at some point of time, that's a different component. But those labors were ultimately used for construction job. It's not that the made up and the levy has been made upon him so far as those components are concerned. So this part should not be again levied upon him. Yes.
That makes sense.
Well, Mr. Kyle will explain why the TDS Form 25 that has been taken to be a basis for levy of service tax. First, he has to overcome the exemption, your submission for exemption. Lakshmi. Lakshmi Narayana, what? Lakshmi, yes, yes, yes. Lakshmi is always in your favor. Revenue. Lakshmi is in favor of revenue. At times, they should also favor the SSC. Lakshmi should also be in the favor of SSC at times. Why? SSCs cannot have Lakshmi. Is it your copyright? First, let us see the provisions. You, Lakshmi Narayan, paragraph 33, 34, 35, I think. But he's not raising any issues on that. But otherwise, you say that Lakshmi Narayan covers which part? Yes. It's an appealable order. Now, this writ is pending since when? 18. We'll not relegate at this moment to appellate. Okay. No, we may not be too much impressed with that. We'd be requiring our assistance and response to the argument that the work was not per se for supply of labor. And for supply of labor, you cannot make an assessment in terms of cubic meter or running meters. 42. No, that is one part. No, understood. But that one part, Mr. Todi has already, Dr. Todi has already conceded. Yes.
Benefit, a commission of 7.5% if we paid to you. The above rates, irrespective of the work being supplied during the normal work hours, but given normal working hours. Then there are 4.5. Similarly, an exception to the work.
No, Mr. Kyle, we want to clarify from you because Dr. Todi has said that yes, there is also one part for supply of laborers. This 4.4, is it pertaining to that part or is it pertaining to the entire work? So that part he is considering. You bifurcate for those. Yes. Yes.
Construction of road cannot simply can specifically accepted by or in the notification.
Mr. Kyle, let us be very clear. Should not be any confusion. What we have understood that yes, he is making a challenge on certain grounds that there is exemption. Even if we are not going into those, whether that notification of 2612 would be applicable without even going to that. He has also, towards the last part of his arguments, said that there is another component which is only for supplying of labor. For that, the matter may be different. It may not be for a construction of a road, it may not be for construction of an irrigation project. Now, these two at page 42 and 43, these tables, which are no doubt on per hour basis, these are in the context of that component of the work or in connection with the work in question. But if you find those tables where cubic meter has been stated, what are those work? Oh, yes, yes. 4.7 has taken into consideration this notification of 26/2012, both for roads as well as for dams, canals. Category empower internet supply service covered under section 65 to 54 of the as amended and state payment of the service tax which is a section by all level. So this 4.7, Mr. Kyle, just one more clarification. The findings at 4.7 come to page 26. Yes. 26. This is in connection with the work order of 1st of July. Now this is in terms of cubic meter. So this is a works contract. This is not a. So this you have to just explain page 26, the table along with your assessment made at 42 and 43 in annexures 3 and in annexure 3, the tables, 3 tables. And this levy is only on the supply part, not the works contract. Well, from where do you get, we have to be, there has to be a specific statement or some documents. Oh. Let us see your affidavit in opposition. What the records? These are the records. Yes. Therefore, last 5 lines starts from I am of the considered. Okay.
The figure will say, you know, the entire contract was more than now. Is not the figure taken from the, from the 26 years. With the independent, division.
This will cover your cover his argument on the TDS that form 26 AS.
The second land is in place, construction benefit. The fact which otherwise, the fact remains surprised. One of the procedure also, which is the of the power of the notice to convey the declaration of their business activity for the central local department, and they themselves register pay service tax including tax directly and on time. Further, the program tax and evidence, they find their custom all staff, the same notice is provided here is fair to discharge. And secretary application provided in 2024, and service tax in 2024. Moreover, I find that the same notice is find its after you return. Some of section 78 of Municipal has amended where it rules 7 the service rules 2024. Number 4, and they were to find a state or they were to declare their activities to the International Center of Civil Authority amounts to the full act of intent to repay and for service based on some of the document that there is no doubt that the same notice is guilty of submission, tax and misrepresentation of fact. Therefore, not only simply paying whatever the provision of section 71 of the Municipal 94 was compared to the
Yes.
discuss all these things around. Based on the six there into the supply. There were certain items are exempted. There were the case. How does it highlight? Maybe not to find a big. I don't know what's it going to do.
Okay. We'll consider. Any rejoinder is necessary? Yes. Yes.
Really,
28-29 और एक मिनट रुकिए ये तो हो जाए yes that you have shown
providing technical service, internet or equipment supply services, please select follow. These figures were considered. Then next page 29. The table again, the losses and the gross value which is to be considered for failure services. Table for debit well, gross figure value is 39,22,493. The losses as compared with the table on page 28, figure of 426 days of
okay
second is the value for banks, if it is higher, that figure is being considered, and the total amount tax service tax rate is 8,44,785, which has been levied. It is not that this figure is not considered, but this figure in entirety has been considered for legal service.
Heard Dr. E. Todi, learned counsel for the petitioner. Also heard speak S.A. Kyle, learned senior standing counsel, CGST, the who has also produced the records in original before this court. The hearing is concluded and judgment is reserved. We'll deliver it very soon, early next week. Records written. Written. Yes. Who's yet to file? NHAI. Who's for NHAI? Madam Bora was here. Where is Madam Bora? Yes, Madam Bora. Hey, to leave. Yes. You wanted to file some affidavit. No, we said that you can file, parties may exchange instructions less file affidavit. That was on 25/7/2025. Yes. You have got instructions. 22, why the instructions? It's at the stage of instructions. Matter of 2022. Madam Sharma, what is the matter about? Who are you? That we know. Yes. You have a petrol pump. How are you aggrieved? What is the distance? We have seen petrol pump within 200 meters also. 103. One zero three. Yes, yes. Hmm. Hmm. Yes. Hmm. Yes. What is the meaning of undivided carriageway and divided carriageway? What is your allegation, madam? Hmm. 5, 6, and 7 have chosen not to appear and contest. What is your allegation, madam? Where is your allegation? Page 70? 77. Yes. Yes. Please read 78. $83. Yes. 4 point. Yes.
Divided category, is this fit, how many were? If you give deceleration and acceleration. Now you also, if you also sees the node, page number 84, the minimum distance of 300 meters between two statements on both sides of the highway for undivided category. In case of divided category, with no gap in between the distance restriction is not applicable on the side of the big stage. And the minimum distance between the two fuel stations on the same side shall be 1,000 meters, unless the access is through service road. So, here there is no service road. In the map, this. Map and what comes on the same segment.
Here in page 77, which is your petrol pump? Where is it? This is yours. But yes.
Said that the NOC was given by the concerned receiver. But our instruction says that no NSC was given by the receiver master regarding setting up of the order.
What about the earlier NOC? NOC regarding the proposed petrol pump? Where has been stated? How did it this issue crop up?
Which was already given. Concerned receiver.
Okay, it is the allegation of the petitioner. You have verified that no such NOC has been issued. No, NOC issue may come at a later stage if it has not been, till now, not been given. The challenge is on the aspect of the guidelines. But on the other side of the road, madam, we find that petrol pumps are there in proximity. Are these guidelines mandatory in nature? Number one. Number two, what is the objective of these guidelines? Page. It looks like the case of Gloucester Grammar School. Where do you derive your right from to make a challenge? What is the meaning of damnam sine injuria, madam? And the other one, injuria sine damnam? Where is your legal injury? What rights of yours have been violated? Your commercial interest may be affected by what is your legal right? Having another petrol pump. It's for the basis, for the benefit of the consumers. And the other petrol pumps are on the other side of the road. These two petrol pumps will be on this side of the road. You have to establish a legal right to maintain this petition. Guidelines don't seem to be mandatory, and it cannot be mandatory. See, the other aspect of no objection, those are within the prerogative of the deputy commissioner. They can decide. But now, can you preempt even the project? You cannot. We do not know why they are not. What is the position now? What is the position? They have gone ahead with the petrol pump or what? There was an order of not to formally commission the fuel station. That means it was constructed. What is the ground, Mr. Das? What is the actual information, the situation, ground level situation? No, that is on the documents part regarding the construction. You take instruction. What was the, because this private respondent is not interested in the litigation. So, but we still want to know the factual situation. What is it? Okay. Yes, is what heard Miss S. Sharma, learned counsel for the petitioner. Miss R. Bora, learned standing counsel NHAI, however, submits that instructions are still awaited. While this court grants further time of 2 weeks to Ms. Bora to obtain the instructions, so and thus the Learned State Council is also directed to obtain instructions on the status of the proposed petrol pump of the RESPA number 7. RESPA number 7. Full stop. Huh? No, not company. Of the 7, who will be opening? 7. Sri Das has, however, clarified that though in the writ petition there is a mention about no objection by the concerned district commissioner, he has got the instructions that till date such no objection has not been issued. List after 2 weeks. Interim order passed earlier to stands extended till the next date of listing. এইখিনি তাতে থাকিব দেই, এইটো যে ডাঙৰটো ঘূৰাই দিব লাগিব। Yes.
Sometimes out there from red. All of the construction of 1950. Now, the original owner, he sold their property to restaurant 456. 456 my lord, what is the business? Business filed a suit balance, and that suit balance they have contested, and ultimately that suit was decreed. The time my lord, you offered the land, they refused to accept the land, where the political land in court. They also filed a suit for eviction my lord, and that suit is going on. And in that suit, my lord, they filed a executive petition, also stating that I have met some construction. Ultimately, that executive petition was rejected. Now, what happened, from a third party that yes, was a complaint before a GMC that some wall had been constructed. And on that basis, my lord, a notice has been issued to me of the club that the soda permission. I think I don't know what permission is there. Then the landlord, then the landlord, my lord, they issue notice of landlord also took deadline. Ultimately, 100 persons came and from portion of my the top, the factory that had been demolished. I said, place that fellows. It has been that case, my lord, personally. There is no construction, new construction, my lord, here. Nothing has been said, my lord. We have lost this, but then GMC has filed the affidavit, and we have annexed one document, my lord, that this construction of 950. If your GMC has not produced their record, my lord, if they have produced the record, everything will be clear. That we are the construction 950.
Mr. Borayo for the GMC. What do you say?
Procedural. Because it's only four. They come and actually be getting with you. They themselves, they either reply, say, you don't have any occupancy certificate, you don't have any. After there's the 195, the petition that, order was passed, the next one has been. And this order, they keep 15/7 to them 4 years. Right, so that's already. One time. I select a photograph also, my lord. What they have removed, my lord. It's some that house.
But the challenge is against 15/7/2024. Your challenge is against 15/7/2024, which has already been acted upon.
Yes.
You also pray for compensation. Compensation, you can approach the civil court. You have to establish that the demolition was illegally done. Let us see 15/7 for a moment, 15/7/2024. Page?
Page 195.
195.
Where they have carried out comprehension of RCC structure, there is no RCC structure at all, well. Assam like. And Assam like house, without of taking required building permit, and this document being generated to the building will be bylaws, with the jurisdiction of the Guwahati municipal, that covered by Dr. Khan. Consigned structure, structure, the constructor will below, that's right, at both sides, and there, and repair this, punishment alone with that. Well, this was given to the landlord. And notice under section 137, asking to go into the undertaking, undertaking work of direction, direction of building, and proper it is a 7 days. And why the outside construction should not be done. You have submitted a reply. Seven of this, under circumstance, yes, sir, our confirming the the order to remove and pull down the unhealth construction. Now you can also see the photographs, but here, there is space. 186 or not.
Who is this Prabir Pukastha? You are.
Then,
The landlord from property. He has been occupying that.
Just a minute.
also see page this photograph, fellow. Easy level of. Acidic construction and what is done. My active a lot is all the only programs are okay. Yes, yes.
But this demolition has already been done. Now, now if we interfere with 15/7/2024, what will be the effect? Will there be any effect?
Because there are no contract of what they have done, what they have demolished. This is the line was should factory, old.
No, what is the relief you are expecting from the court? 15/7 has already been acted upon. The second part, damage, we can go to the civil court.
Part of the demolished, they will again come and demolish it. Should factory or office.
No, that has already been demolished. The wall has been demolished. Come to page 192. Everything is there, demolished. The walls have been demolished. Now there will be no question of further demolition. For illegal, if you term this demolition to be illegal, you have to establish that it is illegal. You approach the civil court, will grant you liberty. There cannot be further action. Mr. Chaudhary, what do you say? Hmm.
There was in fact two-story building.
Oh.
Construction has been made by them, and it's not done within 1 day. This has been, they have been doing it since 2016, and there have been disputes, madam. And we tried one injunction petition because of, in the main suit, there was no prayer. But for, prayer was not made, there was some defect regarding,
Is there any injunction order which is operative? No. Okay. What kind? No. What kind of injunction? What? Not that injunction which you had failed to get by the court, that has been already done by the GMC. Now, if they think that has been done without there being any mandatory injunction, or that the entire description in the GMC is not matching with the property which has been demolished, they can file a suit for damage. They are tenants, maybe by sufferance or whatever. Till now, you have the dispute is there, but you are the tenant. You are inducted as tenant. You are seeking the rejectment. They're paying the rent in the court. Okay. Tenant by sufferance almost. Yes.
And that record alone, there's a year of contract we are working with people.
Okay, we'll give you liberty. Okay. Heard. Yes. Hmm.
RCC on the ground floor and CIC definitely use their second. Paragraph 11 I have described all the. Because this is after visiting by the officers.
CI sheet on the first floor.
The RCC ground floor operated with CIC at the one portion and then RCC structure is
case code is like 1.3 CDI quick and 3 side back and 3 setbacks with 0 margin. That is no margin. It's said with a.
And this construction has been done by them, not by me.
Hello there. So what notice is super bound. Your notice is C basis 186.
Hmm.
That is super.
How my bank makes sense.
Hey, 186. Yeah. No.
So 186 is the document fixing. That's so good. Document last lecture give the document. You have the custom. Tradition 1 and 2 notice you go. That is
No, that is another aspect. This is the data for context of one only. Nothing more. Data below there, go when you survey everything. Data there you go. There's what
see the document action. So we taking action on the second preparation one.
and the reply I have given that I have not changed out any construction except while crossing.
The working get the notice, you pay the much 48 my ticket.
If necessary, Commissioner may be appointed and he can inspect.
Okay, heard. Sri G. N. Sahevala, Learned Senior Counsel, assisted by Sri Mr. Chopra. Who's there?
Chopra.
V.K. Chopra. Sri V.K. Chopra for the petitioner. Also heard Sri S. Bora, Learned Standing Counsel, GMC, as well as Sri M. Chaudhary, Learned Counsel, for the respondent numbers 4, 5, and 6. Mr. Sir, please have your seat. No. The approach to this court by invoking the jurisdiction under Article 226 of the Constitution has been made challenging an order dated 15/7/2024 issued by the respondent number 2 under section 337 within bracket 3 of the Guwahati Municipal Corporation Act 1971. Full stop. It is the case of the petitioner that though the impugn notice was issued in the name of the respondent number 4, comma, on the basis of the said notice, the tenanted premises of the petitioner has been partly demolished with a further apprehension to demolish the other parts. Para. The relief prayed for in this petition is extracted here in below. Relief put kore dibe, ha? Para. I have heard Sri put koloni ke put kona. No, here pisat ko I have heard to pisat ahib. Extracted. Sri Sahevala, the Learned Senior Counsel, has submitted that there is a civil dispute going on between the private respondents and the petitioners who are the tenants. Full stop. He has submitted that the petitioners were the tenants of the erstwhile owner who had sold the property to the respondent numbers 4, 5, and 6. Full stop. The said respondent number 4, 5, and 6 has instituted a title suit for ejectment, which is presently pending. Full stop. The petitioner has also instituted a suit for seeking a decree not to evict without following the due process of law, and both the which was decreed, and there is no further appeal preferred against the same. Full stop. he has submitted that even the application for injunction filed by the respondent number 4 has been rejected. Full stop. However, the respondent number 2 has issued the impugned notice dated 15/7/2024, and though the same was in the name of the respondent number 4, it is the premises of the petitioner which has been partly demolished. Full stop. He has submitted that the notice which was issued to the petitioner, notice was issued prior to the impugned notice dated 15/7/2024 was only on the aspect of the boundary wall and setback and not to any other aspect, whereas in the impugned order dated 15/7/2024, several other aspects have been taken into consideration without giving a proper opportunity. Full stop. The learned senior counsel submits that the notice itself dated 15/7/2024 being illegal, all subsequent action of causing demolition are illegal and are to be declared as such. Full stop. He has also submitted that appropriate directions should be issued for payment of compensation and damage. Per contra, Sri Bora, the learned standing counsel GMC, has clarified that the initial notice dated just a minute. Initial, just a minute. Dated 28/9/2023, correct? And then that 28/9/20 was not a notice, but was not a notice per se, but it was only a communication asking the petitioner to provide the necessary document in connection with the construction. He has reiterated that the said communication was not issued to the respondent number 4, but to the petitioner, and cannot be construed to be a show cause notice. Full stop. He has submitted that the notice issued, that the communication issued on 15/7/2024 has been done by fully adhering to the law, and since it was found that the structure in question was constructed without due permission and without following the norms required, the demolition was done, which is strictly in accordance with law. Para. Sri Chaudhary, the learned counsel for the respondent number 4, has submitted that the construction in question is not done by his client, but by the petitioner in violation of the tenancy agreement, and therefore the action taken by the GMC cannot be faulted with. He has also reiterated that proper notice was issued to the petitioner before the demolition activities was conducted. Full stop. Para. The rival submissions have been duly considered. Yeah, that we have seen. It appears that there is a civil dispute between the petitioner, who is the tenant, and the respondent numbers 4, 5, and 6. Full stop. The said dispute is on the aspect of ejectment of the petitioner. Full stop. While this court has also noted that in the suit filed by the petitioner, there is a decree not to evict the petitioner without following the due process of law. Para. The petitioner had contended that the instant impugned action has been done on the behest of a third party who has allegedly lodged a complaint. Full stop. It is submitted. It is tried to be projected that the action has been taken without any bona fide and only as a tactic to evict the petitioner from the tenanted premises. Para. The such contentions are, however, strenuously disputed by the private respondent. Para. Be that as it may, comma, this court has noted that pursuant to the impugned order dated 15/7/2024, the premises in question has been demolished to a great extent. Full stop. While the petitioner has contended that the premises is a temporary structure, comma, the GMC in its affidavit has clearly stated that the structure has a structure or RCC on the ground floor, and there were CI seats on the first floor, and the said construction was done without following the due process of law. Full stop. Though this court is of the opinion that the allegations and counter allegations are in the realm of disputed questions of fact, which this court may not be in a position to make any determination. Full stop. The subsequent prayer for compensation is directly connected with the first prayer to declare the notice dated 15/7/2024 as well as the subsequent action as illegal. Full stop. This court is of the considered opinion that since the demolition has already been done pursuant to the order dated 15/7/2024, comma, there no effective adjudication or relief can be granted to the petitioner in the instant case. As mentioned above, comma, the aspect of disputed questions of fact is also there, which requires to be adjudicated, which requires to be raised and adjudicated before a competent civil court. Full stop. This court is also of the view that the aspect of that in the event the petitioner is successful in making out a case that the impugned action is illegal, comma, the consequential aspect of assessing the damage would undoubtedly require adducing of evidence, as the damage is not an unliquidated damage, but one which has to be based on the damages actually caused or suffered to the petitioner. Para. In view of the aforesaid discourse, comma, while this petition is closed, comma, liberty is granted to the petitioner to approach the appropriate civil court for the relief. Full stop. Is there any interim order? No, we'll protect you till you Sri Sahola, the London Senior Counsel at this stage, submits that there is an interim order by which further demolition was stayed. Full stop. Para. To balance the equities, it is directed that while the petitioner, that the liberty granted to the petitioner to approach the civil court be availed within a period of an outer limit of 3 weeks from today. They are already there. You can avail 80 You can avail 80, section 80. Within 5 weeks. 5 weeks from today. And 5 weeks from today. And the petitioner would also be at liberty to pray for an injunction along with the suit. Full stop. In this period of 5 weeks, comma, or till such consideration of the interim relief, comma, the interim order passed by this court shall remain operative. Writ petition stands disposed of. Petrol. You file affidavit. You need to file separate affidavits.
They have held on negatively, it will cover in all that. I have wordless still. Cover in all that, right?
They want to file affidavit, let them file. It will be better for you to respond. Or how soon? 1 week? Okay. Heard. 3. J. Ahmed, learned counsel for the petitioners in these cases. Para. 3. B. J. Talukdar, learned additional senior advocate, has submitted that insofar as WPC so-and-so is concerned, the affidavit has been filed. Full stop. The affidavits are also ready for the other writ petitions, which would be filed, for which he prays for some more time. Para. List after 2 weeks. 2 weeks, by which time the affidavits in the other cases are also required to be filed. The petitioner would be at liberty, petitioners would be at liberty to file rejoinder affidavit. Date after 2 weeks, you tell us. Today is 4th. 19th? 19th September.
Person committee has finally approved. But that's you right, fill for police yesterday, he heard about it. So I created a letter to listen to it. Not Monday. You are here, please.
Oh, two committees.
Yeah.
Polita for? What is the name of your client? What is the name of your client? Guwahati Qabristan Committee represent and Mr. Farizi, your client? Qabristan Committee. Name? Are these different or the same? Who has signed file the wakalatnama? Who has signed the wakalatnama? Let us see who has signed the wakalatnama. A blue file too. না ওয়াকালাত নামাজে আছে এসব ফাইলটা থাকে ব্লু ফাইলটা থাকে না পুরোটা তলত
Implement, I think, is not a record. The working place issue is Guwahati for us.
There's a constitution of overturn, that is what it produced, so that in course of constitution and working condition six, is behind the overturn from the.
These are your wakalat number, Mr. P.K. Raj Chaudhary. Where are the other wakalat number? Oh, along with the affidavit, perhaps. Let us see the affidavit, your affidavit, Mr. Kolita. Oh, no. Hey, I'm looking for the wakalat number. Who is Farid Ali? Is whose client? Yeah, okay. What is he? He is the. That's, we want to see the wakalat namas of both of you. Where are the wakalat namas? Wakalat namas are not here. There are two wakalat namas in favor of Mr. Roy Chaudhary. আছে নে wakalat nama? Huh? Wakalat nama নাই? এখানে থাকিব লাগিছিল wakalat nama file. এখনটো এখন হেৰি P.K. Roy Chaudhary and Hawk. P.K. Roy Chaudhary and Hawk. ওখানে আছে. You want to keep it. Okay, let the wakalat nama, let the, yes, where are your wakalat nama, Mr. Dhar? No, we wanted to look at the, have a look at the wakalat nama. Please check the records. We are not getting your wakalat. Neither your wakalat nama nor Mr. Kolita's wakalat nama. এইখিনিও দি দিয়াচোন. Somebody had filed for implement. Yes, who? No, maybe in the implement application, your wakalat nama is there. Yes, we have. Wakalat nama. Who is the Keuddin? No, Keuddin is the advocate.
They have no official agreement that has not been decided.
Then Mr. Kolita says that he, for implement, this is by whom? Nayanjyoti Gogoi, Jitumoni Kolita. This is by whom? Jamal Ahmed, President. And this is Dhar and Faridi by Working President. If there is a president, how can there be a working president? You say he has resigned.
Yes.
You forced him to resign. Have you put all this in your affidavit, Mr. Dhar? No, that will be an important issue. See, now the dispute is no longer with the petitioner. The dispute is between two respondents.
That is really depends on. So they cannot file. But that is not my affidavit.
No, to challenge their locus, you have to make some statement in your affidavit. That is what we'd like to have a look. Let the affidavit come on record. We'll have it when? Tuesday we have many matters, but still this will come in admission. We'll have it Tuesday. Thursday this court will rise early. Next Thursday we have. Or if it then it might go to the Tuesday thereafter. It might have you might have it on 16th. 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 Okay. Heard Sri P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard Sri who's for the state? Sri B.J. Tarukdar, learned addition senior advocate for the state respondents, Ms. G. Hazurika, Senior Counsel Revenue. Full stop. Sri J. Kolita, learned counsel, is present for the respondent number 5 to 12, whereas Sri Edhor. But 5, are there 2 5? How can there be 2 5? Huh? Who is 5? Who is 5? No, who is 5? 5 committee. While Sri J. Kolita, learned counsel, has appeared for the respondent numbers 5 to 12, comma. Sri Edhor, learned counsel, has also submitted that he has been entrusted to appear on behalf of respondent number 5. 5, which has filed a separate affidavit today, yesterday. Full stop. Since the said affidavit is not connected with the records, not tagged with the records, matter is adjourned to be listed on 16/9/2025 along with the affidavit. Have you been served, Mr. Kolita, of this? You serve copies also. The affidavits which have been exchanged, no, copies of the affidavits which have been filed be exchanged amongst the learned counsel for all the parties. Full stop. The parties may also file additional affidavit. The parties may also file the learned counsel, Sri Kolita, as well as Sri Dhar, may also file additional affidavit to explain their contradictory position in the 2 respective affidavits. Interim order passed earlier to continue till the next day of listing. No? You take back this constitution.
Actually, last order taken 11, which was supposed to file an
Who?
Canara Bank.
You are for the bank?
I'm for that. I would make the direction of filing affidavit on behalf of the Canara Bank. There's only one point. This petition outright not prayer.
Where is Mr. Sharma? M. Sharma? Yes, where?
They are the private party.
No, where is M. Sharma? Is he there? Well, okay, we'll have it at 2 o'clock. You have filed your affidavit. Yeah, would you like to file affidavit? Okay.
That's why I'm saying that.
Page 17.
Where one, reading the nature of random child, the response wants to put to strike out the name and previously of the response of 5 to 6 from the same account to but therefore, this is one of the prayer which are entertained by the family of gospel. Now, just look for a moment, paragraph 5.
Prayer 5.
Paragraph 5, page 8.
Of the repetition. Yes, please.
Hereby, the petitioner stated that due to the dispute over who ought to be legitimately representing the interest of the society, the petitioner should not employ the president, secretary, and dispute title to number 38.
Yes, yes.
Thereafter, by
Yes, then the case before this court, 107 of 2024.
Let him put it whatever, because notice the eviction, there is a direction given to the bank to give. Order may be complied, okay, if he has an objection, but it's undisputed. It is their critics, correct? Section 9 by the ombudsman clearly said in case of any complaint, every party can approach the ombudsman.
Why don't you settle the matter?
I think it's
No, why don't you settle? If there is even a slight chance, we will have a mediation. Huh? If you want a mediation, can be at Tinsukia. You can have a mediation here, Guwahati, or at Tinsukia, wherever you say. They are, I think, members of the same family.
No.
You are 4 to 8.
But what you can see that in some situation, my lord, it is disputed tax FI from their pleadings, my lord. And act is very much clear, Ombudsman Act, section 9.
Okay, you file your pleadings. We'll try to dispose this off at the admission stage. It is at the notice. Notice has been issued.
And
You-
then the bank filed a.
You can also file your affidavit. Heard Sri R.J. Das, Learned Counsel for the petitioners. Full stop. Also heard Sri M. Sharma, Learned Counsel for the respondent bank, as well as Sri S. Chamaria, Learned Counsel for the respondent number 7. Full stop. Sri Chamaria has raised serious issues on the maintainability of the writ petition by submitting that the dispute involved can be raised before the banking ombudsman. Full stop. Let an affidavit be filed by the respondent number 7, wherein the aforesaid objections may be taken. Full stop. The respondent bank may also file the affidavit in the meantime. List after 2 weeks. Give a date if you want. List on today's 4th. We'll have it on 19th. 19th, 2 weeks. This you can present on the next occasion.
So, any, but 6 and 7, daily appear, 6 is the execution and 7 is.
You have reconnected. Okay. Yes, Mr. Das, more than Mr. Pathak, I think you have something to say. Yes. Regarding what? No, that is okay. We are on the major issue. Electricity is the temporary issue. On the eviction issue, what do you say? You get that? I think that is more important. And these are what kind of lands? Forest land. Have you done a verification exercise? If it is patta land, you cannot evict them unless you acquire the land. That's a different matter. No, it is, they have already said they did not object to acquisition if it is done by the due process of law. Yes, yes. Okay. Heard Sri M.K. Hussain, learned counsel for the petitioners, para. Sri K.P. Pathak, learned standing counsel, APDCL, has submitted that in terms of the order dated 25/7/2025, the electricity has been restored. Full stop. Sri Hussain, the learned counsel, has endorsed the said submission. Para. Sri Endas, learned state counsel, however, prays for some more time to obtain the instructions. Para. List after 3 weeks to enable filing of affidavit in opposition. All the respondents are otherwise on board.
Six. I can appear first.
So we can say, okay. Okay. Also पढ़ लेते हैं. As regards the service upon the respondents, comma, Sri Pathak, the learned standing counsel APDC, has clarified that he would accept notice for the respondent number 6 also. Likewise, comma, the Sri Endas, learned state counsel, would accept for the respondent number 7. No, additionally, would accept also for respondent number 7. Okay. Yes.
By already 7.
Yes.
And if that they say that it has been filed. Now, my lord, as per the office note, dated 17/25, has not yet lost the record. It has been yes. We have received the
Copy is there.
copy is. I will provide a copy.
Will you provided to what is the?
But the main issue here was that we had sought for a transfer of investigation from the state police to any other agency because this is a matter which pertained way back to the year 36. And due to some shorty investigation, every time there was a final report just filed, we had gone for a magistrate. And every time the magistrate had directed that the investigation should be done. And finally, after 3 final reports, now they are saying that finally they have filed a charge sheet. So which vindicates me, my lord, that since analysis have been made to wait, and in between a lot of disciplinary proceedings had also been initiated against the heading officers. The recent one being that they had apparently lost the case records of the fight, and when an investigation was conducted by the SP, it was found that the concerned OC of that time, he had neglected in pursuing the file, and it was found to be locked in a box for a long duration of over 10 years. Therefore, it was in that context.
Who are you, you're Mr. Barua? Who are you?
I'm for a petitioner, my lord.
Understood. Who is the petitioner?
So the petitioner, my lord, was residing in a house, wherein there was some theft. Some of my goods were missing, and I have given an FIR
Okay.
against 4 specific persons, out of which one was a civil servant, and he had some influence. Because of the influence, every time a final report was returned. Civil service is not civil service, that's not the context. Whatever is a landlord tenancy. One of the accused was ECS officer was posted at Colina at that point of time. It's a fact. And because of that. No, but in the FR, yes, by name it was not there, but we were repeatedly saying that the investigation was not done. Finally, they have purportedly submitted the charge sheet. I need to go through whether the accused have been implicated or not. But my lord, the main thing here, my lord, is that I am aggrieved because of this undue delay, my lord, that has been caused since 2006. And even after.
Let us have a look at the charge sheet.
But the officer was made a party in that. It is there at page number 60 of the. Page number 60. 60. No, I'm sorry.
He is not a,
Subsequently dismissed from service.
no, he's not a party in the proceedings.
Yes, ma'am.
Yeah.
These authorities primarily. I wanted a change of the investigating authority, as well as some compensation for the injustice that was caused to me. Now they are saying that they have, after all these years, they have filed a charge sheet. After a lot of departmental inquiries were held and my case record was locked up for over 10 years. But perhaps in the case, which is fit to be awarded compensation money. No, it's a particular because you know,
Your allegation was against who, which of the accused? Names? Yes. Nimai Saha has been charged. Dilip Roy Chaudhary has been charged. And Jayanta Sarkar has been charged. They have been charged under 294, 506, read with 34. This charge sheet has been laid when? Why is the delay, Mr. Das?
They are basically completed. Final report is still final. They are, when the report was filed, but they came with the company for the reinvestigation. Yes, again, the reinvestigation present finally, my lord, an inquiry was conducted, we have got to an pre-judgment. It is at page 161.
Well, where is your FIR, Mr. Borwa? FIR?
I mean, kindly word also which you could place for 159.
159.
So that was the observation of the learned score. Based on the final report that was filed. I do not have the record one record, my lord.
If you're, see, your entire endeavor to come to the red code is to have the investigation completed in accordance with law. There, I think there will be some FIR. Your name is Kisan Lal Singhi. Just a minute, just a minute. Rotate the. Now the charge sheet has been filed, they'll face the trial.
This, the rules are totally different from the charges under which the FIR was registered in the first place. Our allegations are of house trespass and loss of goods. However, the charge sheet alleges obscene songs, criminal intimidation. These were not my allegations. Now different charges are been.
So IPC consent.
Remember 16.
IPC con. See, there is a, from the earlier document, from the earlier FR, it appears that there is a civil dispute between you. You are a tenant, you were a tenant, and the allegation is that you left the premises. Then after the landlord sold this property to the private respondents, and thereafter the dispute started.
Yes, I will inspect for that. We had been staying on the property for quite some time, and because of our wrong stay, we had an agreement with the landlord, and yet sold us the flat. And after that, it was my daughter's examination in Guwahati, so I had to visit her. And it was at this point of time that these people had entered my house, taken away my objects, and caused vandalism. And it was
They have
the
also
fact-
claimed that they have also purchased the property from the original landowner. Hmm. Now, now that is your allegation. That has been investigated. Investigated, and the charge sheet which has been laid, there are different kind of findings. No, see, if you can make all sorts of allegation. Now, investigation ends up with a final form. It can be in the form of a final report. It can be a charge sheet. Now, charge sheet has made found allegations of 294 and 506. Now, if you read the contents, how these sections have been said to be attracted, the allegations, the investigation materials which they have collected are towards that line. You will have the venue to peruse it in the court. It is before the court.
Even if that matter is
I know.
delay manner, that perhaps might not have to be considered because a common citizen waiting for his case to be charged from 2006. That is perhaps
Look at
a risk of justice.
Okay.
And you have found that.
Just a minute, Akhil Karot, Provitent, Dalgaon, Thana. Just a minute, just a minute, Raju Kore. Leave it on. One Ananda Saha has passed away. I think he is required to be given a copy of this because we don't find too much of reasons how the conclusion of involvement of 294 or 506 value 34 is made out. There is no much materials. Heard Sri A. Barua, Learned Counsel for the petitioner. Para. Also heard Sri N. Das, Learned State Counsel. Full stop. Though this court wide this court wide order dated 17/6/2025 had directed the Learned State Counsel to produce the charge sheet which was stated to be filed. Para. Copy of the said charge sheet, a certified copy of the said charge sheet has been produced by Sri Das. Full stop. The a perusal of the same would show that 3 numbers of accused persons have been charged under section 294 Reddit 506 no 294/506/34 of the Indian Penal Code. Full stop. Sri Barua, the Learned Counsel, has submitted that the allegations against the accused persons were entirely different, and considering the fact that on an earlier occasion the investigation had ended in an effort which had to be reinvestigated because of the orders passed by the learned magistrate, the fairness of the investigating agency has been questioned. Para. In the fitness of things, this court directs the Learned State Counsel to furnish a copy of the charge sheet to the Learned Counsel for the petitioner to enable him to obtain the instructions. The full stop. The same has been furnished in the court itself, which Sri Barua has received. Have you got a copy of this? We'll keep a copy. A copy of the charge sheet along with the written instructions are also made part of the records. A copy should be made. List after 2 weeks.
Basically, the location of the land of the, whether it was within the prohibited area of the ancient monument designation, and for which not there was an order earlier government wherein the response is directed to file a specific case. So that there is a procedure which is under the use in order to declare a land which is called within the prohibited area. Now, the notification by way of which my land was falling within the prohibited zone was to be produced by my learned friend. Number 1, and number 2 is the affidavit. They have stated that there is some notification of 1992, which is subsequent to an order of this honorable court wherein I was legally protected in the year 1991, wherein my land by an order of this court was clearly mentioned that it falls outside the prohibited area. Now, my lord, there is a judicial order, my lord, an order which has already taken finality, my lord. And thereafter, they are saying that my land still falls in the prohibited area. Now, my lord,
Oh, if you understand correctly, you had relied upon a judgment of this court dated 2/7/1990.
Yes.
And Madam Gayan had said that subsequent to the judgment, there is a notification as per which will have a relevance in the present adjudication. And therefore, Madam was asked to get hold of the notification and produce it. Have you got it? Yes. Which notification? Oh, this is the notification then. This notification is there 1992.
saying that initial monument Davidol and the peripheral area of 100 meters in all directions are basically prohibited area. But what the rule contemplates, my lord, under Rule 31, that before you bring this notification, if there are any plot of land within this prohibited area, you need to notify that particular incumbent or the person falling within this 100 meters to give them a chance to reply and to give them a chance to rebut. Give them a chance to rebut and to reply and object. The purpose is like, my lord, a land acquisition process. If my land falls within a acquisition process, I need to be notified. A prior intimation has to be given to me. Now the problem here is, my lord, they have a notification there, but they do not have any notification intimating me that my land falls in this periphery or in the prohibited zone. Now, my lord, the whole thing is boiling in only one simple issue, my lord. If my
And
land
that means you are contending that on the notice part, that you are not notified by any notice that you are under the prohibited. Yes, where is that
Yes.
notice? No, we understood in a different manner. We thought that he was talking about the notification of the prohibition. That may be an admitted part, but he may have a point that yes, you have to give him a notice that yes. Where? It cannot be. This has to be this cannot be in a printed manner. It will be a case to case. Where? The senator gave 1 month's notice of its intention to declare. That is for the declaration. Now, once it is declared, if somebody is found to be violating these rules of 1959 and 1952, you have to afford him a notice, say that you are in violation of this. Where? Is such notice there?
is trying to bring the notice, this proposed notice, by way of which, my lord, you have directed me to remove the structure, my lord. That proposed notice will not do, my lord. With all due respect, my lord. Proposed notice will come into play only if my land falls within the peripheral zone or the prohibited zone. First, they will have to satisfy it.
Where is this present what is this? Davidol. Where is the mention of Davidol here in this notification?
Their affidavit, my lord, they have just notified at page 84. If those has been notified as an ancient monument, my lord, that we do not dispute. It is indeed an ancient monument, my lord. But where is the notification given to me? The intimation given to me?
Let us see the so cause. Page.
So, in 2011, and the final order was passed in 2015. For directing me to remove my first owner. May I read now? 2-3 Romani under show cause notice under which.
Page 60.
May I read?
Just a minute. $63, yes.
Yeah. This is a- Whereas I understand and of the opinion that the unauthorized construction carried out by him near the centrally protected monument, Eviction, that Borisaka, this is within the prohibited area of centrally protected monument is in contravention of provision of Rule 33 of the ancient monuments and remains 1959. Whereas the central government by this notification, this is what certified 16/6/1992, published in Gazette, declared areas up to 100 meters from the protected limit and further beyond up to 200 meters near or adjoining protected monument to be prohibited or regulated area respectively for the purpose of both mining operation and construction. As such, Sri so-and-so is hereby informed that the unlawful construction raised by him within the regulated area and failure or refusal to comply with an order made under Sub-Rule 1 of Rule 38 shall be punishable with imprisonment, which may extend to up to 2 years or with fine which may extend to up to 1 lakh, which goes under Rule 39 of the state rule. Amended rule that is 2010 manual. This part of the come why this is not even applicable to me, the penalty part. Therefore, he is hereby directed to show cause within 7 days from the date of issue of his notice that as to why an order under Sub-Rule 1 Rule 38 of the so-and-so rules be not issued to remove the said construction which has been made unauthorized, is further directed to stop illegal constructions, unauthorized constructions being carried out in the associated area illegally with immediate effect. Now we give a reply to this local engagement law. Our reply is at page 64, which basically gives the whole background, also highlighting that there is actually an order of the Honorable High Court saying that my land not fall within the prohibited or regulated area. So question of me, there is a one of the provisions application has notified if the land falls within the area to apply a license to construct. So if I may take a lordship, if I take a lordship, to that rules, my lord could find that if the area falls in the prohibited zone, then I need to apply before them. So they are saying that I am the license holder. I don't need to be a license holder because my land doesn't fall within the prohibited zone. Then after that, my lord, the thing rested for a while. Then, my lord, there was already a case pending, because of which there is no person.
No, in the earlier round, this court has held that your land is outside the. Then.
Why? After a few years, they come with this stereotype notice, show cause notice, and they give us. And when we reply to them, they sit for a while. Then again, somehow, my lord, for some reason or the other, they will come with another notice. Now, if you notice before your lordship, at page 67, has been issued on 10/11/2016. Lordship, I kindly see.
Yes.
This is the notice they have put the challenge before this honorable court. Is they have issued in 2015. So what were they doing from 2008 to 2015?
After the show cause notice was, issued in.
It was in 11.
11, 15, 18, 20. Again, 15 day came up with this notice, I have to come prepared for the action and file this connected action. Now the whole question boils down to a simple issue, where in order dated, if I may quickly take a lordship to order dated 13/9/2022, passed by this honorable court, the certain queries were raised by this court, they need to fulfill those queries that bring to the record, if at all they have, if I may take a lordship to order dated 13/9/2022.
In the impugned order at page 67, is there any mention of the earlier High Court's order?
Because in my representation, I have given, if I have highlighted that there was already a case pending, which has been decided, there's nothing,
I have noticed that also that before the 2011 also, that I have said it in page number 77, there is a 4 of 5.
And look at pending come to the.
Just a minute, please. This annexure L page 67 appears to be an independent notice. No, is an independent notice without taking into the aspect of the show cause of 2011. Madam Gan, how can you do this?
Page number 96.
No, all said and done, there is a finding of this court, division bench, I think, that the area of the petition under the position of the petitioner is outside the prohibited area of Davidol. That finding has attained finality. Now, in 2011, you again initiated a show cause. It did not reach to any conclusion, abandoned it. Then again in 2015, there is no connection with the earlier show cause. You cannot just go on and on every time. If it has been interfered by this court once, either you have to get it corrected by a larger bench, higher bench that has attained finality. And 2011 proceeding, that 38 2011 proceeding, has not, you did not even lead it to a logical conclusion, you abandoned it. Now, how do you again initiate a proceeding in 2015? This will be an unending process.
Okay, sir. Can see that it is then I can see the earlier that.
Yes.
That man not come under the prohibited area. And in that section, my lord,
Date of the judgment? The division bench. Thereafter, what has happened, madam? What do you say?
Page 28.
Just a minute. After the judgment, is there any change in the law or change in the situation that required you to issue another notice? Which one? 1990. Yes. Now, No, the original notification, which is at page 84, that notification for DBW is already there. Now, what was the restriction earlier? In the earlier proceeding before the High Court, what was the restriction which was taken note of the High Court?
All the more important for them.
No, Mr. Borga, you just tell us in the earlier proceeding of 1990, which ended up with 2/7/1990, what was the cause of action?
But this plan was granted by the government, and after giving the settlement malus, according to the due process, it was cancelled at the behest of some individuals, and the honorable minister did an review, saying that my land falls within the area.
Oh, that is what? What was the area?
Say 1952, they have come with that area of 100 meters. At that point of time, there was no 100 meters area apparently, but I could learn from the judgment now. So it was, the judgment contemplates my lord, it was far away, it says, from that particular dark under which my land is also, is far away from living.
Far away would be a subjective thing.
We have noticed in 1992, if at all they were having this exercise to be
But
done.
this so-called that page 63, 38, 2011, that was given to you.
Article 31, Rule 31 says that I need to give a notice like a land acquisition process that your land falls. So you need to now either remove your land or if you have to.
That 3811 can be considered to be a notice, but 38 you say that was not taken to a logical conclusion.
Yes.
Now the 67 has again been issued. 67, let's see 67. Now what is this second writ petition by
Both of them, in fact, filed expedition in 1991, 1990 meters. So this order basically is governing both the two petitioners. So again, like the present petition in the next item also, the same process was adopted. I did. So one of the facts are also similar. One plan is contiguous to the plot of plan of the current solution.
it?
Order. Review or have the.
No, there's one catch. See, annexure L page 67 is not independent. It is in connection with the 23/8/2011 notice. Yes. No, first line itself. First paragraph, last line.
The principle is already completed. Without complying to the so-called notice, take a certain.
Let us see the act. Act. 1958 Act. This one? Okay. Section 20A. Where is 20A? 20A? Do you have? Where do you get? This is your own copy, madam. এখন.
The declaration of prohibited area and carrying out public road for other works in prohibited area. Every area beginning at the limit of protected area or protected monument, as the case may be, and extending to a distance of 100 meters in all directions shall be prohibited area. In respect of such protected area or protected monument, provided the central government may on recommendation of the specified specify any area more than 100 meters, it is not important. If I may quickly just take a lordship to the rules, because rules will clarify this part very clearly. My rule 38, they have invoked, first I'll take a lordship to rule 38. Rule 38, my lord.
Tuesday we have fixed many matters. Monday we can try. Monday. You kindly make copies of the relevant provisions of the section and of the act and the rules. Entire need not be photocopied. Heard now while Sri H. Burago learned counsel for the petitioner is present, a prayer for accommodation has been made by Miss A. Gayan, the learned CGC. Sarah, considering that this matter is pending since 2015, slight accommodation till Monday is granted. Para, list on Monday. Item 20. Central Bank of India. Central Bank of India, who is appearing? Arnab Das, NC Das. 20-year for whom? Respondent. For the petitioner. You are the new counsel. Who's for the respondent? Who's Radhesham KD? Sri M. Sharma, learned counsel for the petitioner, has submitted that the respondent number 1 has passed away in the meantime, and he is required to file substitution petition. Full stop. He prays for and is granted 2 weeks' time to file such substitution application.
There is a deliverable charge of 22.7.5. Now, the finance group, making and Assam financial document property. Now, the standard was passed that your lawsuit time that page 16 is a total way.
Now you filed a suit for? Against whom?
Can't still and alloy company private.
Recovery suit. Where was it filed? Bongaigaon. Bongaigaon.
At that time, not there.
There, after your suit, what has happened?
At page 60, it doesn't. Property portion, page 19. Two if we had the last part, page 19.
Just a minute.
Twenty, the suit is liquid expiry, duly liquid, the cost of realization of loan amount of rupees 1 crore 82 lakh and 12 which are interest on a liquid amount is realization amount. In other, it is liquid that the difference number one is a liquid amount. Within a period of 1 year from the death of degree, any which the plaintiff shall be entitled to a final degree as per this reality. So, this is done to me. I have to wait for 1 year, thereafter I should pay for finally. Then so far, proper dependent after financial proposal was not these. Well, these issues, a degree expiry, we have released a degree that cost for realization of rupees 25 lakhs and so, with a future interest of this and so, but a liquid amount is realization of the amount. It is harder to degree that the difference of 1 rupees and different amount the period of 1 year to get a degree, very which the proper dependence shall be entitled to a final degree and 5% charges principal. So they can also file a future for making that degree and
Who are the proforma defendant?
proper now, we send an application after 1 year because the amount has not been paid. We met the degree final. That we have also final degree and payment plan. At page 30, you have also see what are the degree that the money realized by such sale shall be paid to the court and payment amount payable to the plaintiff for the reported criminal degree and any part of others that is passed in the suit and in payment of that amount the court may be adjourned due to the plaintiff as charges expense and then will under rule month together with subsequent interest and then taken under rule month together with subsequent other orders when so and that the penalty can easily pay the dependent or other person and then. So, my final degree passed for the amount, and it said that then the amount will be paid to me, and the balance is there, we have to go to the dependent or the person who are there. Because the dependent will proper dependent, they did not put the degree, put the degree as a penalty. So I have put the degree for exemption, and then in the meantime, the DRT has come. So as per section 91A of the Deputy Doctor, we of the Deputy Doctor and Deputy Doctor will pass the order. On the basis of which we realize in terms of all penalty. But we could not recover the better amount. Partly we have realized and we have adjusted against the see the
Now, what is your grievance?
now,
What?
No, now subsequently, my lord, Assam Financial Corporation approached the debt by Limited, saying that we have 22 staff, my lord, and we should get it. Well, they have not made approach to the court, my lord, for making the decree final, so far their degree is concerned. We have only, my lord, made our decree final.
What happened to that application that before the DRT? Then what is
Then
it?
in the DRT, directed me to pay Namo, charging 22 and 7.5. So far, they can make the degree final and they can realize it. They can put the degree in execution. Because
But
they
the
have
dec- But the preliminary decree which you had paid for the final decree to be passed and executed by the executing court, that will not cover the entire amount.
that is
So what practical purpose will they have in how much is the amount involved? How much is your share?
1 crore 80 lakh and odd plus interest.
Total
Total.
decree.
1 crore lakh. And there was 25 lakh and odd.
1 crore 22 lakhs.
2 lakh.
82 lakhs.
Yes.
Total. Then your
That is another aspect. So far, they are quite concerned, they have got the degree.
how much is your share, Mr. Kulta? Theirs is 37.5. 22. And the rest? Were there any other secured creditors or what? Then? No, this is not 37 and 22 will not make 100%. Rest?
That is not a degree, my lord. The degree, my lord, you can also see, final degree, after is, my lord. If you process it, let's see again.
Or realization, they are super, or they are in
My lord,
1 crore 80.
1 crore 82, and the final degree, also, my lord, your lawsuits were 29A, my lord, that saying, my lord, it is again, your lawsuits must see, my lord, page 29. The final order, taking the money realized by sale, then it paid in the court, and sell, payment amounts plenty under the aforesaid decree, and under the final order, that has been passed in the suit, and payment of amount, the court may charge due the plaintiff for cost, charges, expenses, has been payable under the one. Together with subsequent interest has been payable under the one, together with under order 34 for the first schedule of the court of the procedure, and then the balance if any, well, that is very. Balance if any, shall be paid the defendant or the person. If my share, well, my amount is satisfied that there is excess amount, then only they will get it. As part of this final agreement.
And the balance, if any.
Yes.
And you contend that after final decree, the amount which has been paid to you, thereafter, even your
Yes.
claim has not been satisfied.
That is my lord, I challenging this my lord.
Let us see the impugned order by the in his petition.
My lord.
The impugned order.
My lord. Yes. No, no, well, this is an order page
51.
Um,
28.8. Impugned order? Is it 28/8/2014? Page 51 is 28/8/2014. 81, not 51. I think we should read the impugned order, then we'll have a fair idea.
The first order is at page 43.
Which order is this?
Yes, that one, that is, that requires that. I will try.
43. Forty-three is by the DRAT.
Yeah. Now, if you look at that, come to another page 45 after.
Page 45.
And figure available on the query, that there was a very first agreement prepared. Interest of head, and extent values are sometimes the purpose is in the ratio is 7.5 to the 2 in the annual property concern. Consequently, the very first agreement was to provide as you put as well as here in such case, the axiomatic term, the extent for any one two parties says the the parties are entitled to their respective shares, but one cannot simply take away the share from the other. The employer shall lead the entire sale proceeds, accompanied, any some financial process of taking instead to report that due, whether that due or the budget itself, they feel ultimately help the leadership agreement to be given. That's of divisional, that's right by the industry of our council, do not forward. Here, the earlier past the judgment, recognizing the very document and because yourself, not to actively, not keep for a bank to dictate the terms of the assumption, to take activate steps to obtain a certificate to the recovery. On balance, in view of the matter, I know it took up all that conclusion. And bank share for the
Parties are entitled to respect. But page 45, the last line, is the last observation so unreasonable? The parties are entitled to their respective shares, and one cannot simply take away the share of the other. The recovery officer wrongly released the entire sale proceeds as if Assam Financial Corporation has not taken any steps to recover their dues. No, but won't they be entitled to? They will be entitled to, as the decree has attained finality. No, decree has attained finality. No, is there any challenge to the preliminary? There is no further challenge.
They only want that they are the value that they should get their share. But it is not that value that they have approached for final degree. They could have approached for final degree and then activity. They can ask to the matter. We have already adjusted the amount.
But will they be deprived of their? They are also a financial institution.
Yeah, this is the matter that I.
And if you go by the pari passu distribution, it is 37 and 22.5. 22, 37.5. How much would be the of the decretal amount which is available? FD. Huh?
Then again, find the recovery.
One thing we cannot be by voting party to make it final. There was only 1 crore 8 lakh.
And how much was your share?
Only 1 crore 8 lakh.
And how much is your in the Mr. Kolita? Your contribution? No, in reality, how much was their contribution? Okay.
35 lakh. Yes, that is mental here on page 67, that his share will be 40 lakhs 11,000. From that 1 crore 8 lakh, which is taken as benefit charge, then it will be 67 year old page 67. Just can you consider by
67.
yes, that's basic. We will also see, they option that mortgage and building also, for some of it 1 crore 8 lakh thousand, and the entire amount shall proceed be taken by the applicant to the school number 4, for the entire option shall proceed of 40 lakh 11,070. That's by their flat by nothing.
Yes. See, these are public money, both of your financial institution. How do you resolve the issue? How do you resolve the issue? Money is important to you, money is important to them. They are also dealing with public money. Page?
It can go to court. Yearly court. They have not declared. They find the declaration. It is their fault that it is not our fault. They have to pay according to their amount, the amount. At that time, my lord, the DRT asked to keep the amount in.
Fixed deposit.
Present.
Both of you senior counsels, you make a suggestion, you make a, how do you resolve the issue? Both of your financial institution, both. No, that is what we have not understood. Is it required for to file for final decrees by 2 parties? Is it required? Now, a final decree, you apply under what provision of law? Some CPC concern.
That's not whatever the super, again, this is the our super. But the same amount. They are trying to get the ultimately intact. Because
No, the recovery was first in the civil court. And after the coming of the DRT Act, it was transferred to the DRT. After 93, because the institute was instituted prior to, I think, 93, 92.
public, after DRT that come, battery level aspect, your office that consider 67 basic.
No, no, under what provision is final degree?
Then after degree, very clear, that recovered amount excessive any is there, that will go to the defendant or other person. That's very clear. They are not challenging.
No, 6 is decree and 7 is the date of the decree. Now, where is the provision for a preliminary decree and a final decree? That if there are more than one decree holder, then each one has to file separately for final decree. What is the language of the final decree, Mr. Sayola? Which page? Page 29A. We have just read 20. Yes, we have read. 29A.
Other order and decrease the money realized by some then you pay in the court and so payment amount will take it, the opposite other orders have been passed in the court and in payment of the amount. Which the court may adjust due to the tax cost charges expenses as may be payable under rule 1 together with subsequent interest as may be payable under rule 1 together with subsequent under order 34 as in and the balance even make the defendants and other person that. Hello, we have and we I just would we have take the the court key we have paid to the everything we have done well. Then we have made the final final so for our part.
And you are the plaintiff here.
They were the proper defendant. They were the proper. They have not discarded any cost value. They have confiscated. I think from them because they did not pay the fee and other thing. But that's 67 then.
Let us see your the prayer at page 13. Yeah, it is humbly.
I cannot fight. So, as per judgment, my lord, even then. As per the judgment, my lord, then how can we fight for final degree? We cannot. It's directed. They have to make it there to final degree. Cannot fight for final degree. The judgment is there, page 20, they have the first objection. Separated account, regarding account. But no, I am not entitled to file any application for final degree. Yes, that's nice. That's what page 20. Yes, also file. Yes, I think also.
No, that is why we wanted to be we wanted to be apprised under what is the provision. No, what is the provision for applying for a final decree? No, that will clarify everything because your challenge is against certain orders of the DRT. Page 67.
Can be if taken 22.
That you have shown already. No, that is what our concern is. They are also dealing with public money. Yes, yes, where is it? We wanted to have a look. Page? $26.
receiver or other, in money they have realized, but either of them shall be applied towards the repayment of the principal interest, cost and other charges due to the corporation. And the UK Bank in proportion of the total amount due by the company on the date of such enforcement. Yes, my lord.
This financial, this relationship started when? Was it of 1977? And with the pari passu agreement, 1977. And the recovery proceeding was instituted when? 92. Which led to the decree and then subsequent execution of the decree.
Part of democracy. In their debate, there isn't it.
No, no, the pari passu agreement is of 1977. And that is a tripartite one, along with the borrower and two of the financial institution. I think this you have to sit together and make an endeavor in this matter to settle. The dispute is not a dispute only on apportionment. They are armed with a decree. They have gone for execution. They did not go for execution. You may have a valid point saying that the final decree can be only done by the plaintiff. DRT, correct?
Order is very clear, my lord. 7,
Page?
Initially, the DRT had given to me.
Page. $55.
I didn't like the environment of it. They have, two appeals before the year 81. They both were rejected.
And here the appellant is the present petitioner. Appeal number 5 of 2014. Yes, Ecobank is the present appellant, present petitioner was the appellant.
Guarantee वाला, original order, उसके पे 31, property possibility करता है.
The amount was given to the coverage of the case itself. Thereafter, the PSP filed an HF into the year. The HF number was 6 of the case. Then they contested the appeal. They had to dispute the appeal with the observation of giving the, yeah. Then the student banks filed an appeal before the DRAT Kolkata. DRAT dismissed the appeal without cost, with cost matter. Then the student filed an application for recovery of 99 plus 55,000. 99 plus 65,000. From the appellant bank, where 32 of the 2009, 37 of the 2002. Appellant bank filed objection. Then recovery of because dispute the application with observation, directed the appellant bank to deposit excess amount received by them of sale proceed with interest and pays 54 million. In brief, we have the circumstances prevail and present completion of certificate holder bank. Following are the order. Expenses raised by the same fee to bypass the order of the learned tribunal as well as order of the honorable DRAT Kolkata. To avoid depositing the excess sale proceed, the recovery officer is clearly unlawful and it is noting but sheer violation of the order of the last DRAT and the honorable DRAT. Is being directed to deposit the excess amount received by them out of the sale proceed, along with interest at the rate of FPR. Near no name interest bearing amount. Every interest at the rate of FPR within next year. Any which action will be taken against the same fee as per the law for appropriate excess amount marked and above there has been allowed to the planning community. It will be directed to furnish the other property, particulars of the CTS, the next day. It will be directed to comply with the above order within next day. Instead, this my lord, they have not, because it is not paid in it. So my lord, final order was passed. So we have to put it forth. We have now can you put your order against that? They have not challenged the earlier order. They can because they were directed, they are visitor. Came to was directed to your solicitor. Final order was 69 shillings. After this order was originally 2014, then final order was passed on 477. Because till then, we are fighting objection, they really matter. In this long period.
Mr. Polita, we have not understood one thing. After the order dated 12/12/2013 was passed by the appellate tribunal at Kolkata, why was this Case 55 instituted? This is against which order? Appeal number 5 of 14. Yes. Now, 12 thereafter, the appeal 5 of 2014 has been eh, instituted, preferred by the present petitioner against an order of 28/8/2014 passed by the recovery officer. What is 28/8/2014?
Recovery officer. Recovery officer dismissed the application with observation. Directly the applicant going to deposit excess amount received by them out of the sale of security.
Mr. Sawala, how will it be maintainable? The matters have already attained finality by the tribunal's, appellate tribunal's order. That you have put to challenge now in this petition filed in the year 2017. No. Do we have understood now? The matters have gone to the tribunal, appellate tribunal has
That is, one of the recovery officer has passed the order.
now the recovery officer is only complying by the orders of the tribunal and appellate tribunal. And 4/7, thereafter you did not abide by 4/7, therefore subsequent orders have been passed directing appearance of the MD. Those we can take care, but this part, the money part, you have to.
So let us see.
Well, how can we go again into a writ court again on those parts? Those have attained finality by the appellate court, and it was not put to challenge. That is okay, but the appellate tribunal's order is of which date? No, appellate court's order is of 2014. You have challenged here as a collateral proceeding when? In 17, not in 17. This writ petition in the year 2017, after this order of recovery order was officer was passed. Difficult. We understood in a different manner. There's a different narration is different. Page? No, that we have seen. That was just seen just now. Mr. Kolita, we'll do one thing. We'll have this tomorrow. Please give me a list of prepared list of dates, the chronology of events. Is it there on record or we don't find? Is it there? We just need a chronology of. No, not this list of dates. I need how it started. You started with the judgment of the decree. What else? The later part of the judgment, so far as appearance on all those parts, will take care. In fact, that has been taken care in the interim stage itself, I think. Those will take care, but others will be difficult.
Entire history was written by detail. There the reality itself has over time really changed. It's surprising, my God. Against the order, they can put certain seventy, they have not, because in the, because reality has already passed quite a lot.
No, see, that filing of an appeal would be without any, that will be meaningless because 4717 has arisen out of an initial dismissal by the DRAT on 12/12/2013. That was not put to any challenge, further challenge immediately. Now, considering that order of the appellate tribunal, 28/8/14 was passed, and which went to this recovery officer. Recovery officer passed an order, which was the subject matter of challenge in the by the petitioner. And 47/2017 is the dismissal order. Correct? Let us have a look at the DRAT order. The specific relief paid for appellant is dismissed in behalf of the person. The aspirant number one is entitled to a ratio 37. No, DRAT 43. Yes. Yes, the question. There was a party passer agreement. Yes, party passer agreement is there. Is it issue? The instance of anyone who. This, I think, paragraph 40, page 45, observations are in accordance with law. We will not have any other alternative opinion. Can you read the last paragraph, page 45? It's to transpire that there was a pari passu agreement wherein the interest of the bank and the Assam Finance Corporation is in the ratio of so and so in the immovable property concerned. Consequently, the pari passu agreement was recognized by the civil court as well as by the DRT. In such a case, it is quite axiomatic that at the instance of anyone of the two parties, the sale could be conducted. The parties are entitled to their respective shares. I think this. What is wrong with this agreement observation? We don't think this is not irrational. Both of your financial institution. It is true that the amount which has been generated from the sale is not even fulfilling your share. That is okay, that is true. But it has to be on a proportionate basis. And both of the status are the same. I think both of you can give a chronology of the things tomorrow. We have more or less concluded the hearing. Tomorrow will be listed only to facilitate you to give a chronology thing. Okay. Heard three. We can hear Mr. Kolita for you tomorrow for only for explanation part, nothing else. Heard Sri G. N. Sayola, Leonard Senior Counsel assisted by Sri M. Sharma for the petitioner. Also heard Sri P. K. Kolita, Leonard Senior Counsel assisted by Ms. T. Goswami for the respondent corporation. Para list both the Leonard Senior Counsel for the parties would submit chronology of events. Full stop. List for further hearing tomorrow. It will by sleep করে দিবা এটা মই চাই লম অলপ 22 Which matter? Okay. Yes, 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 yes. That fraud. OTP.
Respect of few transactions, the ombudsman had held that there is a deficiency in service. But for the other part of the transaction.
Yes, Mr. Monta. Hadrika, yes. Here for whom? The Reserve Bank. Here for the SBI. SBI, okay. এখন তাতে আগতে। Yes, what is your matter? You are challenging the order of an ombudsman. Page
One. Page 61.
dated
Dated 2011/21. It's
61, is it? Yes.
Pursuit the complaint which I have lodged in 11/6/21. So that is reflected at page 62. The complaint number dated 11/6/2021. Is State Bank of India.
Yes.
Here is payment State Bank the account of the year 2000.
There are two petitioners.
And recently, by his surviving.
Petitioner one passed away.
The account to open 20 year, more than 20 years old. account.
Opened when? Joint account.
Five. Third account is the joint account.
All the opened in 2000.
Yes. There was no internet banking in this account. There was no internet banking activated by the petitioners. They were doing their normal transactions. The fraud happened two ways. First, that there was the internet banking was activated by the fraudster. Secondly, the registered mobile number was changed. But two things were this was of the but this is not explained by the SBI. When we lost the complaint, the SBI never.
For two modes of fraud. What is it? First is by changing.
They have activated the internet bank. The mobile number cannot be changed as per the rules without the branch intervention. There has to be a physical application
and KYC documents have to be submitted to the bank for the change of the registered mobile number. So both things can never happen. And therefore, we are alleging negligence on the part of the SBI and their system by which these fraudulent transactions took place.
Yes.
Now coming to at page 62, how the ombudsman has dealt with the complaints lodged by the petitioner, paragraph 2. When the complaint was lodged, the bank has given their version before the RBI ombudsman, paragraph 2 and reading page 62. The bank's version was submitted to us on 18/6/2021, stating the transactions were done via UPI to the internet banking app YONO Lite. The app was installed and activated by the foster with the validation of OTP delivered to the registered mobile number. OTPs were delivered for both transactions. We have submitted that the secret identity credentials and mobile handset of the customers were compromised. It is the responsibility of the customer to safeguard the secret identity credentials and OTP. We do not observe any banking deficiency. The beneficiary details along with SMS OTP logs are attached.
This is the version of the bank. Yes.
Last this was the version which was given to me available in the reports of the RBI in the ombudsman. During the pendency of the RBI complaint, these are the versions which should have communicated to us by email. And second paragraph, if will see, this paragraph is entirely quoted in the impugn order also, whereby the bank has given the details of the amount which has been defrauded from the 3 accounts.
Mm.
And the subsequent part, you will see the last part. Here, sir, the complaint pertains to unauthorized UPI transactions of 50,000 and 25,000 done on 1/6/2021. These transactions were done via UPI through the internet banking app YONO Lite. The app was installed and activated by the software with the validation of OTP delivered to the registered mobile number. OTP were delivered for both the transactions.
Yes.
Although in the previous paragraph, the statement was made that more than 10 lakhs rupees was siphoned away by the fraudster. In the previous paragraph, the total amount is given for one account is 5,60,144. For the second account, it is 2,92,263. By YONO cash on the total of which would come to more than 10 lakhs. So the explanation was given by RBI only in respect of this 50,000 and 25,000. The other transactions, how it has happened, those were not explained.
Not by the RBI, by the SBI.
By the SBI. Only these 2 transactions, and that is also reflected in page 62 order, which I have just now read. For both the transactions, in the second paragraph, page 62, that was the bank version was submitted.
Now, what are the 3 amounts in this sheet which you have submitted? First is 5,63,000.
from the detail, Malad, as per the complaint,
Yes,
as per the complaint, gave out the details of only the accounts, not 102, not ending with 555,
yes.
100 ending with 973.
Mm.
But the account number 100 ending with 841, the joint account and the customer information file of both the account holders. The fraudster got access to all the accounts. Now from here, Malad, the amount has been mentioned, what has been exactly
Yes.
withdrawn.
True.
For ending with 555, total amount withdrawn via INP transfer, that is number 19, is 5,63,144. Total amount withdrawn from PTM via Uno Cash is 40,000.
Yes.
Then for account number, ending with 973, total amount withdrawn via internet banking is 2,92,643. Total amount withdrawn via ATM Uno Cash is 2,07,500. For the account number ending with 841, this is the joint account number. The amount of 20,000 and 1,54,588 transferred to self account. Now these two amount has gone to the self account, Malad. So this we are not agreed by, we are agreed by the two accounts number. The company liability account against the OTP to the fraudster, the fraudster could activate Uno app and carry out all the transactions. We have lodged request for CCTV and account details of all INP transactions. We request for additional time, submit the details regarding, submit the details. So, Lord,
Mr. Azarke, you are aware of this?
this was first by the email, Malad, which I have annexed, Malad. On page 46. Page 46, Malad.
Yes.
Regarding but Malad, this part what has it was communicated to the you guys are here also. What they have communicated, more I will try to locate, Malad. I think from the records it must be there, Malad. It was sent to me by the to the petitioners by email. So that will not be disputed, Malad. So one part of it is already reflected in the impugn order. The first paragraph which I have read, Malad, where the amounts are mentioned, that has been reflected in the impugn order itself. Exactly that has been reflected, Malad. Paragraph 4. That will page 62. Page 62, paragraph 4. The bank has responded to the query, Malad, to start from the third line.
Yes.
Exactly the same line, they have written. So is there not exact? The amount has been mentioned, which I have already read once. Do not see. Now, coming to the big order. Number page 62, paragraph 5, I will read number. Page 62, paragraph.
Yes, the complainant.
Yes, the complaint. The complaint was forwarded to Paytm Bank and they have replied. Transaction flow, inward transaction, the disputed funds of rupees 11 lakhs was debited from the complainant bank. Maintained with the SBI number of which only rupees 4 lakhs 33 were credited to the Paytm Payments Bank Limited. Output transaction details and beneficiary details attached. Disputed funds were credited to PL wallets and accounts and part of the funds was transferred to the bank accounts maintained with the ICICI Bank, Info Bank and issuing bank SBI. And the remaining amount was withdrawn to the ATM. However, to clear restrictions on the beneficiary payments, bank involved in the disputed transaction, we have recovered rupees 10,000. Our team approached all beneficiary banks involved before these transactions as a disputed transaction on behalf of the company and sought a refund from them. Our team has duly highlighted the beneficiary bank, including the issuing bank. We assured the brokers that we shall arrange for reversal to the source within a day of receiving disputed funds from the beneficiary bank. We also seek the intervention of the brokers in the recovery of funds from the captured fund and scrutiny of the final beneficiary account. Beneficiary account KYC status, the account involved is full KYC account open via biometric based KYC authentication by business correspondent appointed by PTCL as permitted in the KYC MD of RBI Circular Master Direction number dated February 2016. The KYC details of the beneficiary account involved in disputed transactions are enclosed. Number, this is important number. It was observed that even after the complainant had lodged the complaint on 4/6/2021, there were multiple debits and credits taking place in the account of Bharati Kolita, account number block so and so, hence the deficiency lies with the bank as they failed to mark hold in the account immediately, and rupees 1,32,000 was debited from 4/6/21 till 9/6/21. In view of the above, an advisory was issued to the SBI to pay the disputed amount, which was debited even after the complaint was lodged, and they have complied with the advisory on 15/11/2021 and credited the rupees 1,34,600 back to the complainant's account on 15/11/2021 in good faith. The screenshot of the accounts taken into the also attached. Now, Lord, one part of the transaction they have admitted.
Acknowledged.
Prepaid. Other part prior to 4, the ground for rejection is that I have not lodged the complaint. Now that fact is what
From 4 to 9, that part is admitted.
prior on the ground that I have not lodged the complaint. No, that is incorrect because the petitioner has given an information on 1/6/2021 itself to the IVR.
Mr. Gupta, for this period 4/6/21 to 9/6/21, the amount has also been recovered, has been replenished. How much was the amount replenished?
Although I had lodged a complaint on 1/6/2021 itself, to the IVR, on the last occasion, I had submitted the DLR report, SFS DLR report.
We had also made a mention, observation regarding the insurance of accounts. Accounts are insured. But other banks, UCO Bank, I know that is the account.
Yeah, it is, my humble submission is this, on 1/6/2021, when the information was given on the customer care to the SBI, at that point itself, the account ought to have been freezed, They have not done that, it is admitted from the order, between order itself, that, the SBI.
When did the
has not
when did the transaction fraudulent as per you? As
And on 1/6/21 itself, the complaint was lodged through IVR on the customer care, And thereafter on second, the petitioner went to the branch.
you lost through internet banking. What is IBR? You have to call them. What it is called IVR? What is the full form?
Customer care number, there is no customer care number in case of fraudulent transactions, it is the SBI number. The last occasion, I have given one SMS DLR report, which clearly reflects that one of the complaint was lodged on 1/6/2021 itself.
Okay.
I will say it again, what I have. But what has happened, it has gone to that, change mobile numbers. Which is the SMS data report. This was also supplied to us by the RBI, on the email. SMS data report. We see the complaint, the one which I have ticked marked,
Yes.
It shows the complaint number. So there was a complaint lodged, but it went on to the other number. The acknowledgement of that complaint, went to the changed registered mobile number. The fraudster mobile number. At that point of time itself, the SBI should have, there should have been a mechanism when such kind of.
But SBI was SBI aware of this?
Yes,
No, there are two legs of your not argument, the process. You said that if there is a change in the registration number of the registered mobile number, it has to be done by physical verification. You have to go there, change the KYC, and that was not done. So the initiation of this thing by change of mobile number is vitiated, which will entitle you to make a claim. And the second part is with regard to the activation of the internet banking, which was also not done by you at any point of time, and yet internet banking was adopted to indulge in the fraud. Now here, since some part has already been acknowledged by the respondent bank, 4/6/21 to 9/6/21, acknowledged, we have got a complaint, we have taken care, we have replenished 1,34,600. Now the issue is pending for the period 1/6. 1/6 to 3/6.
That I have a submission is that since there is already admission that the bank has failed to mark hold the account after the complete receipt on code. That was a continuous process followed from 1/6, we have made a complaint to IVR. So therefore, at that point of time itself, the bank should have put a hold on the account.
That is a negligence on the part of the bank, Lord. Otherwise, if there is no, what is the use of that?
Just now you have said that though you had tried to lodge a complaint by IVR, it went to a wrong number, a different number.
How could have been
Complaint was lodged on,
1/6?
no, not 1/6, on the 4/6. 4/6 they have acknowledged, or from 4/6.
There,
No, that is, no, from where did they come to know about a complaint? Even on 4/6.
fact, was the complaint on, my information is first on 1/6.
No,
but
no,
when IVR
Mr. Gupta, we're trying to sort it out. You said at 1/6 you had lodged a complaint.
Yeah.
But at the same time, it also appears that it had gone from a wrong number, registered somewhere else. But was it the same complaint which was ultimately acknowledged on 4/6, or was it a different complaint? Same complaint.
1/6. 1/6, we are lodged the FIR also, on the same day. And my lord, page 37, if my lord will see,
Mr. Das, on 4/6 you acted on the basis of what? Just this, we'll come back to you. On 4/6 you had acted, it was on it was on what basis? One?
Yes, two epidemic, and one additional epidemic and one is epidemic. And by the, four measure, that Chelixal measure.
Before this, you were not aware.
That, what I mean is particular.
So even if you are successful in this point, then the point which we have to address is the change in mobile number. How was it allowed?
Provider. That according to quality that we can position ECR, technical ability, OTP or CR as per this.
No, OTP was shared. Put-
Then first I had obtained the duplicate SIM. There is a government of Indian circular is there. That similar situated one case this Airtel was
It means you want to contend that there was no change in the mobile number. A duplicate SIM was.
Yeah. But we are not voted accounts after receipt of the information. Information given in 4 mile and fraudulent transaction was continued up to 9 mile. For 4 to 9 mile, there is a 1,34,600 fraudulent transaction 1 mile. And mile, that is where ombudsman advisory note was directed us to refund back. We already duplicated them. Now, for the additional evidence, so we have categorically stated that let him prove that he has himself informed to the bank on March 2. And because there are no such evidence that he has informed to the bank. Now, everything was his here, and service provider, There is the BSNL has not made a party here also, That is the another aspect, Our thought was only not hold that, accounts, after is done. For a moment, kindly look into my additional
that additional affidavit which the Leonard Friend is trying to say, that was filed after 2 years, but first affidavit was filed in the year 2022. The second affidavit.
We have to continue some other day. Today we have to rise the meeting at 4:30 again. Kali পড়া যাবো নাকি? Kaile? We're almost done. Yesterday's matter, the other matter also will complete tomorrow. Tomorrow we'll finish. How long will you take, Mr. Das?
Only, I will satisfy that the bank had knowledge of the fact on 1/6/2021 itself. Why they are trying to dispute that fact, my lord, because there is an RBI guideline which says that if the customer makes, my lord, in respect of a fraudulent transaction complaint within 3 days of the fraudulent transaction, the customer liability is zero. To avoid that, my lord, they are disputing this date, my lord. And there, I prove from the documents on record that they had knowledge of the transaction.
Your FIR was registered on 1/6.
About 43. This 43, my lord, the letter dated 3/6 was the important moment, but
Okay, we'll continue tomorrow, huh? Okay, we'll continue tomorrow. List for further hearing tomorrow. Well, list kiman lamba? Huh? Huh? Nalage no. Rest two matters will give some dates. Yes. What is the matter about? Sixteenth. And one more matter. Yes, yes, Election Commission. Yes. What is the matter about? The limitation, what the scope of challenge is very limited. Inclusion, exclusion of village is very difficult for red court. And number two, what is the prejudice you are suffering? That is the main question. No, what prejudice will you suffer? This is somebody might, these are not legal prejudice. These may be factual prejudice. At times, delimitation causes some difficulties, but these are done as a matter of policy, not for one person. Objections were called for.